Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. On January 22nd, Judge Stephen Hippler rendered an order regarding presentation of IGG evidence, which is available for you to review if you follow the link that I have provided to the Idaho Courts Cases of Judicial Interest website and scroll down to the 22nd of January 2025, and you'll see the order regarding presentation of IGG evidence. And it states as follows: as discussed with the parties at the January 21st, 2025 status conference, there is a significant evidentiary overlap between defendant's motion to suppress regarding genetic information and the defendant's motion for a Franks hearing, insofar as it pertains to his proffer regarding law enforcement's use of investigative genetic genealogy, IGG. So let's unpack this in English with all due respect to you, Judge Hippler. There's a significant evidentiary overlap. What the court is saying here is that there are matters that pertain to the suppression motion, which is one motion, and the other motion, which is a Franks hearing motion, both of which were filed back in November of 2024. As a matter of fact, a lot of Mr. Kohberger's suppression motions come out and say, in the matters that are under seal, we are incorporating that evidence into the suppression motion from the Franks motion for a hearing. Proffer means what he expects the evidence to yield with respect to law enforcement's use of this genetic information, IGG, materials that he is seeking to suppress that has been, if you have been following this case for any length of time, you know, ladies and gentlemen, that this is one of the most hotly contested issues between the parties in this entire proceeding. So then he goes on to state here that although the hearing set for January 23rd, 2025 is not intended as a Franks hearing, in the interest of time and efficiency, the court will permit the parties to present their evidence on the IGG issue as if it were a Franks hearing. Now, this is rather interesting because if something is noticed as evidence for a Franks hearing, how do we put that toothpaste back into the tube? How do we take that information that's in the bag and put that cat back in the bag again, or any of those other cliches of this was noticed as testimony for a Franks hearing, but really it's not. But this is what the court is saying here. In any event, he's saying that by permitting such evidence, the court is not concluding or even implying, ladies and gentlemen, that the defense has satisfied the preliminary showing required by Franks. This is Franks versus Delaware, U.S. Supreme Court case. This is where the notion of this Franks hearing comes from, and it attacks the warrant affidavit, not evidence. That's what a motion to suppress does. Motion to suppress is seeking to have evidence thrown out. This Franks motion is something entirely different. So he's saying here that he's not implying that Mr. Kohberger has made his preliminary showing required by Franks to qualify for a hearing, nor is the court bound to consider the full extent of evidence if it ultimately concludes defendant's proffer is insufficient to warrant a Franks hearing on the matter. This is simply intended as a time and resource saving reason. So he's trying to, it sounds like, be efficient with the witnesses that are coming forward for the motions to suppress evidence, to be conscientious of their time, the court's time, the attorney's time, everyone's time concerned. This is what this order says. If you would like to read it, and I do recommend that you do read the filings in this case if you have an interest in it, please follow the link and you can do so. This will now conclude this episode of the Indie Zone podcast. My name's Kathy. As always, thanks for joining us here today.